Good morning, and may it please the Court. My name is Jonathan Shapiro, and I represent the petitioner-defendant in this case, Admilson Vizcaino. This case raises an issue of first impression in the Commonwealth. Whether double jeopardy bars a defendant who has been found guilty of summary criminal contempt for refusing to testify under a grant of immunity from being subsequently indicted and prosecuted for the exact same offense in order to impose a greater sentence than could be imposed by the judge for the summary criminal contempt. The Commonwealth argues that double jeopardy simply does not apply to an adjudication of summary criminal contempt. Thus, it argues that the defendant can be punished twice for the same offense, once when the trial judge holds the defendant in summary contempt.
Was he punished twice here? Was he punished twice? I thought he was being held in civil contempt.
On May 12th of 2010, at a hearing, the trial judge found the defendant in civil contempt and
assigned an order having him held till the end of the trial.
The end of the trial.
Well, actually, or a year. Wasn't that part of it?
Well, it was. There were two instances. On the second instance, the judge held him in civil contempt, sentenced him for 30 days, or unless he purged himself prior to the expiration of that time. This was while the trial was still ongoing.
Now, this is such a long trial that I guess I have this, help me with this, I have this very basic question. Why isn't this like breaking two different windows in the same store? He was subject to an order on day one, which he violated, and went to jail, apart from whether it's civil or criminal. And then, 2 weeks later, however long it was, he was brought back in, told to testify, and he violated it again. Why aren't those two separate, discrete violations of two separate court orders? Or can you only do it once? Can you only refuse to testify once in a criminal case?
I think on the second occasion, he was brought back in to see if he basically had changed his mind. And so it was still the same refusal that he had made when he was first brought in. He was brought back after a certain number of days, and the judge said, you have an opportunity basically to purge the contempt. And he said, again, I still refuse to testify, at which point she again entered a finding of civil contempt, but, and this is crucial to the case, at the same time she said, I also find that he has committed a criminal contempt in violation of Rule 33, and I'm going to put off until after the trial a hearing to determine what the actual penalty will be. So to answer Justice Cordy's question, he was not punished for the criminal contempt on May 12th. That was, even though the judge found that he was guilty of the criminal contempt, she put off until after the trial the determination of whether to, of what sentence to impose.
Right, but Rule 43 explicitly permits her to do that.
It does.
So what you're essentially saying is that we wrote a rule which, if complied with, violates double jeopardy.
No.
I don't think the rule permits her to find him in criminal contempt and then.
Well, I thought you agreed that to find summary contempt, the judge has to make a very, very prompt finding based on the conduct before her.
That's true. Yes.
So the judge could not say he's acted badly, and I'm going to hold a hearing at the end of the trial as to whether or not he was in summary contempt. Do you agree with that?
Yes, that is true.
So if the judge had done that, you would say that's not summary contempt. That has to be a Rule 44 contempt.
No, I think the judge can hold the defendant in contempt in summary contempt at the time of the contemptuous conduct. But the rule specifically says if for reasons of convenience, it's inconvenient to impose a sentence at that time, the sentence could be put off till the end of the trial.
Which is what she did.
But isn't there another? Oh, sorry.
But I mean, but you're saying that she acted entirely in accordance with the rule.
Well, except although she could have imposed a 3-month sentence at the end of the trial, she didn't do that. Instead, she bound him over for indictment, and he was subsequently indicted for the criminal contempt.
But the rule expressly permits her to do that, too.
Are you
No.
relying on 43B of the rule, which says that if you're going to do that, then before making a judgment of contempt and imposing judgment, then it's
Exactly.
It's a very difficult rule to
Our
read. But do I understand you to say that this portion of it defines a different process? You either can do a summary contempt, you see it happening, you say, I judge you in contempt because it should be contemporaneous, and then I'm going to punish you later. But if it's going to be, if the later is going to be, or if your contemplation is that it's going to be in excess of the 3 months, it's going to require an indictment or a complaint.
Exactly.
Then you have to be mindful that before you judge, right, you may say you're going to do that later, but you can't judge twice.
Exactly. We think that the rule basically says that at the time of the contemptuous conduct, the judge has to decide whether to punish that person as a summary contempt, or if he or she thinks that a longer sentence than could be imposed for the summary contempt is warranted, then to, before adjudicating the person in criminal contempt, put it off for a subsequent hearing, at which time the person could be then indicted and tried for an indirect contempt.
So if the judge sees something going on in the courtroom, the judge should say, what? I find that behavior contumacious, and I'm going to refer it for prosecution? Or I find that, if the judge says anything, I find that contumacious, and, I'm going to hold you in contempt. But let's get on with the trial, and we move on. Are you saying once the judge basically says, that was contumacious conduct, I find you in contempt, that's it? The judge no longer has the option at that point of being able to refer it for prosecution?
I think once the person...
Once the judge says you're in contempt.
Once the judge makes that finding, that, in our view, is putting the defendant to trial and
that's
constitutes
it. The judge
form of
doesn't have the
jeopardy.
choice anymore to say to the
And
prosecutor.
however, we don't think it puts the judge in a difficult position. The contumacious conduct takes place. The Rule 43, provides that the judge can have a preliminary hearing during which he can consider whether a summary punishment at that point is appropriate, or if the contumacious conduct is such that he or she thinks that a longer sentence than 3 months would be warranted, it's easy enough to say, I'm not imposing any, making a determination as to contempt. I'm putting it off for a hearing at the end of the trial.
So I guess the thing that's bothering me here is pity the poor trial judge. What are you supposed to do? You see something that you know is contemptuous behavior, right? Because it's happened in front of you.
Yeah.
And do you pause to say, I think that was contemptuous behavior? What do you have to say for yourself, giving somebody some notice? At which point they explain themselves, and you think, well, that's contemptuous behavior, but I don't think 3 months is going to do it, and so I'm going to say nothing more here other than that I'm going to refer it to prosecution.
Could you in that situation, are you saying it would be all right for the judge to say, you're in civil I'm finding you in civil contempt, and I'm going to put you in jail until the end of the trial unless you testify, and I'm leaving open the question of criminal contempt? Would that be all right in your view?
I think that certainly would be, because it's clear that the courts have made a distinction between civil and criminal contempt. And a determination that a person is in civil contempt does not create jeopardy for a subsequent prosecution for criminal contempt. And that seems to be clear throughout the case law.
So the problem, since this judge found twice, her error, in your view, is by saying, I find you in criminal contempt. If she said, I find you in civil contempt, and I'd like to hear what you have to say about criminal contempt, and I'm not making a judgment about that, that would be okay?
Yes.
But if she did that, you would tell us that's not summary contempt.
Well,
Because summary contempt has to be done at or about the time of the event.
that's right. And
So she then would be waiving her opportunity to give summary contempt by delaying.
that is true.
And if she doesn't waive it, but then decides to postpone sentence until the conclusion of the trial, which she's expressly permitted to do, then it's double jeopardy.
Yes. It's not, in our view, a difficult choice. And here, we're not talking about conduct, disorderly conduct in a courtroom. We're talking about simple refusal to testify under a grant of immunity, which doesn't raise any of the issues which the Commonwealth raises and which some of your questions suggest, where there has been disorderly conduct and the judge is faced with a decision as to whether or not to impose an immediate sanction in order to control the courtroom.
Yes, in that regard, was what's your view on whether summary contempt was even available here? The language of the rule suggests that it's available when it's necessary to maintain order in the courtroom.
The rule does seem to suggest that that is what is required. However, the case law from this court and others is clear that a refusal to answer a question under a grant of immunity is considered a summary contempt, and that a judge is justified in imposing summary contempt in order to protect the authority of the court.
Is Rule 43 inconsistent with the statute itself, Section 28?
I don't think so. I think that it can be harmonized with the statute. As we've indicated, we think that Rule 43 basically requires the judge at the time of the occurrence of the contumacious conduct to make a determination at that point whether this is a summary contempt which warrants a 3-month sentence or would satisfy the interest of the court in imposing a 3-month sentence, or if it's a more serious contempt, in which case it's not appropriate to make a finding of summary contempt at that point and to, at a later time, refer the case for prosecution. That's the decision which we think the rule requires to be made by the court at the time of the occurrence of the conduct.
Why can't this be considered just one continuous process? The judge declines to impose punishment, even though she's made a finding that contumacious conduct has occurred, declines to impose punishment, and refers it then for further proceedings under Rule 44. Even if there was, even if jeopardy attached, why do we have to see this second alternative, as you suggest, as being, an either-or, a choice that the judge has to make at the time of the conduct? Because that's really what your scenario requires of a judge who witnesses contumacious conduct, must make a split-second decision whether or not to call it as she sees it. That's contempt. Or, because if she does that, then she's committed to having it be just summary contempt. Why can't we see this as one continuing process?
Well, I guess the answer is that the double jeopardy clause prohibits it being treated in that way. The issue is when the judge makes a determination, considers the facts and the law, and makes a determination of guilt, that is former jeopardy. And that unlike the situation in the old trial de novo, which gave the defendant the option of appealing and wiping out the conviction, where the courts have said that's a situation of continuing jeopardy and does not involve the double jeopardy clause, that's not the case here, because the defendant in this case has no option. In fact, the Commonwealth's argument is that it has the option, if it's not satisfied with the finding of summary contempt, to indict and prosecute in order to get a more serious sentence.
Mr. Shapiro, your time is up.
Thank you, Your Honor.
May it please the Court, Joseph Ditkoff for the Commonwealth of Massachusetts. With me is Mark Hillel. He was the trial prosecutor in the underlying murder case. Your Honors, the first thing I want to say is I can't see any way there can be a different double jeopardy rule for a summary contempt that involves refusal to testify versus one that disrupts the court. There's going to have to be one rule on how summary contempts work as far as a summary contempt that warrants more than 3 months. And that's really what the Commonwealth wants, is the procedure, whatever happens with Mr. Vizcaino, to know what the procedure is for a summary contempt that warrants more than 3 months. Now, it is not realistic, as my brother says, in most cases, or even in this case, to determine at the moment of the summary contempt what the appropriate sentence would be. And this case demonstrates that. We had a lengthy hearing on May 28th where the defendant produced numerous arguments on why his contempt should have been punished by 3 months or less, explaining his fear of danger to his family, and for the judge to make that decision without allowing the defendant an opportunity to explain why he has a 3-month or less contempt, which the rule says he gets an opportunity, at least a summary opportunity, to produce argument and evidence on sentencing, is unfair. Furthermore, a judge at the moment of a summary contempt, she doesn't know what the defendant's record is like. She doesn't know what consequence his contempt is going to have for the trial. In this trial, and I think this goes to the question of whether summary contempt meets the rule necessary to maintain order in the courtroom on refusal to testify. You take this case where we had tremendous trouble in getting people to testify, not just this witness. This is the only witness who said, I just won't testify, but people that had to be capiouses, people had to be dragged in.
Yeah, but she could issue civil contempt, and she did. And that serves the purpose of, basically holding a sword over him and saying, you testify or else. So he's he's incarcerated. But he can free himself. That's the thing about civil contempt. He can purge himself. He holds the keys to his own cell.
That's correct, Your Honor. He was found in civil contempt twice, first on May 4th and then on May 12th.
So it's not like she's without tools to handle the issue there.
That's right, Your Honor, though those tools were inadequate to get him to testify.
He didn't testify, but, it's still, to the extent that we're looking to protect judges' ability to manage the courtroom, that civil contempt in this instance did that. The question is the punitive aspect, the lesson to be taught to the other people out there who don't want to testify. That's what the judge was concerned with.
I think that's true. I mean, obviously there'll be summary contempts where you can't have a civil version of it because they're not violating an order. That isn't this one. You do have a situation, of course, if people stop testifying in a trial, the trial is going to fall apart. So the judge might need tools beyond civil contempt. But in this case, that is the case. The rule, as this court said in Arisian, says that this is what you do. You have your contemporaneous finding of contempt. You have your sentencing hearing. If it's more than 3 months, you send it on to be prosecuted. And the reason why this is constitutional, just go to the Melvin Smith case, which is the last Massachusetts case the Supreme Court did on double jeopardy that came out of Massachusetts. Now, there was a case where a judge, at the close of the Commonwealth's case, acquitted the defendant on the firearm charge, and then later changed her mind and submitted it to the jury. And the U.S. Supreme Court didn't say, it said it was an acquittal, it was obviously an acquittal. It said it wasn't because there was a judicial finding that therefore there's a double jeopardy problem. They said the reason was because there was no rule, there was no statute, there was no case that said it could be reconsidered. So there was an expectation of finality. If there had been a rule, and this is why the Massachusetts may have lost, but the Solicitor General of the United States won that case. The feds have a rule that say you can reconsider. And they said that's fine as long as there's already a rule that says this, because there's no expectation of finality. Here, you have a rule that says that you can, that if the judge decides it should be more than 3 months, that it will go to prosecution. So that when the defendant is told, I find you in contempt, he knows that there is a process that may end up, if it's more than 3 months contempt, in him being brought before a jury. Or obviously you can waive a bench trial. It's just the same thing as, say, an OUI case, like in the Jarvis case, someone gets found in OUI, guilty of operating under the influence by a jury. And he can't say, well, that's it, I've had my fact finder, they found me guilty. You can't now do the greater offense of OUI fourth in front of a different jury. Why? Because he knows at the time that that's not the end of the story. The rules say there's going to be a further process to determine whether this will actually be a higher sentence.
To accept your argument, we are first required to accept that the description of that process in a footnote in a case is the accurate description that binds us, and that the rules are clear with respect to the process. I'm not sure I see them so clearly. I mean, but that's correct, right? We need to say to ourselves that anybody reading this will know that once a judge says you're in contempt, that is an ongoing process. It's not final until at some point down the road the judge says, and actually I'm going to, you're going to be indicted. We're going to go further. I want you to be punished by more than 3 months.
Well, I don't think that's true here, because at the very paragraph, if you look on pages 78 to 79.
You're arguing that she didn't mean judgment. She was just using loose language.
No,
it also depends on that.
Your Honor, she specifically says, when she says, I find that Mr. Vizcaino has committed summary contempt, in the same paragraph she says, and if I come to the conclusion after, this is page 79 of the record, and if I come to the conclusion after hearing both sides that I would indeed sentence to more than 3 months, then I would at that time refer the matter for prosecution under Rule 44. So there's no question that this defendant knew that this is the way these rules are being interpreted. I think it is the natural interpretation of these rules. But Mr. Vizcaino can't claim that he thought there was any different process, because she specifically told him at that moment that my brother says is the key moment, that that's how it was going to be.
But did his lawyer object to that?
Well,
I mean, I don't think there was agreement with the judge that that was the right reading of the rules. I mean, that's what the judge decided to do, but that's, I mean, it's not like that was just the unanimous consensus there.
I don't agree he objected to that, but I don't think he had an opportunity to. In the May 12th hearing, the defendant kept saying it can't be a summary contempt, because it can't be summary contempt unless there's a contemporaneous finding of contempt, which is why she says this in the first place. She doesn't really get an opportunity to say, well, I don't agree, that's the process.
But the question is, isn't it, how do you read these rules? So the judge either has to make a determination, I'm going to go with summary contempt, or I'm going to refer it for prosecution. And once she makes a finding, then she's made the choice. That's the argument, right?
That is my brother's argument. But what the rules say is you can delay.
Well, it's not so clear what the rules say, I think.
These rules, I mean, are not a model of clarity. It's something I said early in my brief. But I think the one thing that the rules, do say very clearly in Rule 43B, if the judge then determines that the sentence he would impose may be in excess of 3 months imprisonment or a fine of $500, he shall bind the contemptor over for trial to be held in accordance with Rule 44.
So
What exactly, I'm sorry, Your Honor. What exactly is she supposed to do before that? The rule is a little contradictory on, but it's very clear that once, and the sentencing can be at the end of the trial, as it was here, the rule says that too, that at that point it can be sent over. That is the one thing the rule leaves no doubt about. My brother's just saying because she did a 43A2 finding before that, that suddenly that's taken off the table. But
You don't disagree, I take it, that if Judge Fabricant had said at the end of the trial, you know, I held you in summary contempt and I'm going to give you 3 months or whatever it is that summary contempt permits, that you couldn't then, the prosecution couldn't then go and seek an indictment for contempt under Rule 44.
in this case, definitely I agree with that.
I'm sorry?
In this case, I definitely agree
Is
with
that
that.
because of double jeopardy?
Well, I mean, we specifically said that's what we were going to do. Now, if you don't accept my argument that double jeopardy doesn't apply to summary contempts at all, then there's no question that is the case. If double jeopardy applies, then once she says it is going to be a 3-month or less contempt, then there's no way you can be prosecuted for that same. I mean, it's a little more complicated in here because, as Justice Spina pointed out, there are 2 different instances of him refusing to testify. She makes the finding as to the May 12th. We actually indicted the May 4th, but I don't want the court to get too sidetracked by that because this case isn't really about Mr. Vizcaino. It's about how do you do this in the future, and that's unusual to have.
So what do you say a judgment of contempt in 43A2 means?
That is the judge's statement at the time, a preliminary statement that you've committed
So
contempt.
you basically say that means a preliminary finding of contempt is what that, I mean, that's not the language we generally use to refer to a preliminary finding of contempt.
I did say preliminary. I don't think that's the right word because we're talking about a situation where the judge has personally witnessed the entirety of the contempt. I mean, we're not talking about probable cause. We're not even talking about beyond a reasonable doubt. There's absolutely no doubt the defendant has committed contempt.
Well, that's not fair because the defendant has the opportunity, at least a summary opportunity, to provide evidence relevant to guilt or punishment. So even if the judge sees conduct before her, she still has to give him an opportunity to be heard.
Absolutely, I agree with that. But to say it's preliminary, it's only preliminary in the sense that she has to give him an opportunity to explain, and then has to decide whether it's 3 months. It's not preliminary in the sense that she's saying there's probable cause that you did it.
But if you're saying it's preliminary, why didn't your indictment read that the contempt occurred on April 12th?
Do you mean May 12th, Your Honor?
May 12th.
No, the first time.
The first time was May 4th, and that is what our indictment says.
May 4th?
May 4th was the first time the defendant refused to testify.
Okay, so why didn't your indictment read May 4th instead of May 12th if it was preliminary?
It does read May 4th, Your Honor.
Oh, okay. I thought I heard you say May 12th. I'm sorry.
May 12th is the second time. It's when the judge makes this finding, but that's not what we indicted.
Okay.
We indicted the May 4th the first time.
Could
He refused. Yes, Your Honor.
Is it your position, I guess I'm not, well, you have the judge doing something with summary contempt, and let's assume the court agrees that doesn't bar a prosecution. At the prosecution, under Rule 44, the judge's determination doesn't come in at all, does it?
To the jury? No, Your Honor.
So it's totally new about whether, A, there was contempt, and B, well, and obviously the punishment's going to be for the judge, but...
Well, we have to prove it with extrinsic witnesses, Your Honor. Absolutely. You don't have to prove anything to the judge in a summary contempt point because she's witnessed everything. That's why she has to do a recital of all the facts that she found, because otherwise there'd be no way to review it as an appellate court.
So is it so is the way you look at it somewhat equivalent to a bind-over proceeding? I mean, a probable cause proceeding in the district court or binding, for indictment?
But the rule says bind over, in fact. I mean, that's actually what it says, is she shall bind him over for a trial. I mean, this is something that doesn't happen in Massachusetts much, but you can have in systems where people actually get tried for 6-month crimes. You can have this problem. But here it says...
So he would get credit for time served. Under the summary contempt, if he were convicted under the criminal contempt under Rule 44, he would get credit for time served under the summary contempt under Rule 43?
He hasn't served any time for summary contempt.
It was civil contempt. That
He was held for a while, so he get credit for that. But he hasn't served any time for summary contempt.
Okay.
He's been
I'm
held for
sort of
civil
confused by
contempt.
your use of the word preliminary. It seems like it's all part of the same proceeding.
Right. Well, it is part of a continuous proceeding, but there has to be a contemporaneous finding of contempt at the time, and only afterwards, and it can be as far as the end of the trial. In this case, that was 2 weeks later, that the judge finds, first of all, can give an opportunity for the defendant to argue on guilt, but then finds whether it's a 3-month contempt or greater than a 3-month contempt. So preliminary only in the sense of it's the first step.
And your view is that the conviction of a summary contempt occurs only at the time of sentencing?
Sentencing, or at least in the Dean Gannick sense, when the judge says this is a 3-month or less contempt, and there's nothing left to do to pass sentence.
So only when she declares that she does intend to sentence?
Yes, that's right. It has to be that way because the defendant has to have an opportunity to argue about sentence and guilt. So he can't be given a conviction at that time. And I think Dean Gannick is instructive. I see my time's up.
Please finish your thought.
I think Dean Gannick is instructive because Dean Gannick relies on Therian for its finding of double jeopardy, which I cited in my brief. And Therian says that the reason why acceptance of a guilty plea is a double jeopardy event is because nothing was left to be done but pass sentence. But here there's a lot more to be done on May 12th, but pass sentence. The judge has to give him an opportunity to explain why on guilt and punishment and then decide whether it's a 3-month contempt or not. Thank you, Your Honor.